to guarantee that any worker that experiences a violation of their rights has recourse to relief. And as you mentioned earlier, Chair Manning, in 2017, New York City implemented the Fair Workweek law in response to a crisis of irregular and unpredictable scheduling practices in the fast food and retail industries. The law is designed to disincentivize or prohibit once common practices such as keeping workers involuntarily in part-time status, giving workers their schedules with little advance notice, assigning shifts that vary from day to day and week to week, and assigning clopening shifts that do not give workers enough time to sleep at night between shifts. These practices cause income instability and leave workers unable to reliably schedule other commitments outside of work, like second jobs, childcare, or school. In 2020, the law was strengthened through added just cause protections, providing greater job stability for fast food workers. Under the Fair Workweek law, retail employers must give their workers their schedule at least 72 hours before the first shift on the schedule, and retail employers are also prohibited from scheduling employees for on-call shifts, canceling scheduled shifts with less than 72 hours notice, and requiring an employee to work with less than 72 hours notice without the employee's written notice. Similarly, the Fair Workweek law addresses scheduling instability for fast food workers in several ways. First, it mandates that fast food employers give workers a stable, regular schedule that does not change significantly from week to week. Second, it requires employers to provide workers each weekly schedule 14 days in advance. And third, it requires that employers provide fast food workers premium pay for schedule changes and clopening shifts, as well as the opportunity to say no to clopening shifts or working extra time. And finally, to address involuntary part-time work, fast food employers must offer current workers the opportunity to work more than regular hours before hiring new employees, and cannot reduce a worker's hours by more than 15% without just cause. Since the Fair Workweek law went into effect in 2017, DCWP has received over 800 complaints, launched more than 400 investigations, and recovered approximately $27 million in restitution for workers and $2 million in civil penalties. This includes our settlement with Chipotle for violations of the Fair Workweek and paid safe and sick leave laws, which delivered $20 million to approximately 13,000 workers. It was the largest worker protection settlement in New York City history. And just last year, we secured more than $7 million in worker restitution from Pen, Paris Baguette, and Panda Express for nearly 4,000 workers under the Fair Workweek law. We're very proud of these successes, not only because they put money back into the workers' pockets for harms they experienced, but also because they ensure that companies operating in our city understand the importance of following the law. DCWP also pairs a strong enforcement with proactive outreach. In partnership with community-based organizations, workers' rights groups, and trade associations, our outreach team seeks to ensure that both workers and employers understand the details of the Fair Workweek law. Since 2018, we've held close to 1,400 events focused on our workplace laws, including the Fair Workweek law, serving tens of thousands of New Yorkers. Under Mayor Adams, we have been able to secure $37 million in monetary relief for 28,000 workers through our enforcement of critical workplace laws, and I am immensely proud of these accomplishments. Protecting workers in our city will always be a top priority of this agency. We welcome continued collaboration and partnership with all stakeholders, workers' advocate, and the council to strengthen protections for New York City's workers. This includes ensuring that workers know about their rights and are made whole for violations of the law, and that employers are educated and aware of their responsibilities. I look forward to our discussion and any questions you may have.
Thank you very much, Commissioner, for your testimony today. So a number of questions, and then when my colleagues join, I'm sure they'll have questions as well. So let's just start off with how many workers are covered under the Fair Workweek law?
We have approximately 57,000 workers we believe to be covered.
And how many of them are fast food workers, how many are retail workers, and how many are utility safety workers?
Let me get that for you. Okay. So it's 57,000 fast food, which is the number I gave you originally, and then 203,000 for retail. I don't have the number for utility.
Okay, can you please provide, because I'm concerned with the utility safety that there haven't been complaints, and so I want to better understand that, the utility safety workers. How many?
Chair,
Yeah.
sorry, Chair, I think with respect to utility safety workers, I've been in touch often with the union that represents these workers, and I think subsequent to those updates being passed a few years ago, in many cases, they were able to negotiate CBAs that provided analogous or better protections to our Fair Workweek laws. That said, I've been in touch with them to say, like, if you have complaints, please bring them to us. And certainly, if we hear of utility safety workers, if your office does, or anyone in the council, we would love to work with them to look into and investigate those complaints.
Okay. But in terms of why there are no I mean, I have a whole bunch of questions, but let me, since you're bringing up utility safety workers, what is the reason why there are no complaints so far?
I would say in my discussions with the labor organizations representing those workers that they've been able to achieve compliance with those employers through their collective bargaining agreements. And we haven't, on our end, received complaints, although I'd say complaints, we've been receiving more and more complaints every day since we've updated our systems. But that said, I want to make sure that those workers understand that we are a resource for them no matter what, worker rights, consumer rights, financial empowerment. So we are open to any complaints they might have.
Okay. How many complaints did DCWP receive related to violations of Fair Workweek in 2023?
200?
And how does that compare to 2022?
In 2022, we received 100, so it doubled.
And what about in 2021?
53, so it quadrupled.
And in 2020?
53 as well.
Okay. And in 2022, our information indicates that you received fewer complaints than in 2018, despite the addition of utility safety workers. So going back to 2018, what were the number of complaints?
In 2018, we received 181 for all of our work week.
So in terms of the most common allegations articulated in complaints, is it no written schedule? Is it having to work a opening and a closing without additional pay? What are the majority of the complaints centered around?
Let me have Deputy Commissioner Wagner give you those details.
There are a number of different allegations that we'll receive for those. Some of the common ones are not giving workers access to additional work hours, not posting the schedule on time, not paying premium pay, and more recently, wrongful reductions in hours, just to name a few, but they really do they span the breadth of the law.
And are you keeping track of the number of complaints by allegation for various violations?
Yes.
Okay, so then which allegation has the highest number of complaints in 2023?
In 2023, it's failed to post and provide the schedule.
I'm sorry?
Failure to post and provide the work schedule.
Okay. I want to talk a little bit about Starbucks because there was, as we all know, an article in the New York Times that reported, and this is again using data from back in February, I believe it was 56 stores, 76 different complainants back in February. Some of those complainants had filed their initial complaints in February of the year before. It's my understanding that none of those complaints have been closed out. Can you talk about why that is so?
Thank you, Chair, for the question. We don't really comment or give details on pending investigations, open investigations. Certainly, Starbucks has been shared in the media with some information about it. We are actively looking into the issues that were raised, all of the complaints. We have resources dedicated to that investigation, and as things develop, we continue to be in touch with workers, with Starbucks, getting documents, and we're confident that we will have the right resolution at the right time.
So it's also my understanding that Starbucks was not notified of the complaints for approximately 4 months. What is the agency's procedure to notify companies of complaints?
When we get, just generally in for Workweek, our cases, as soon as we get a complaint from a worker and it's assigned to an investigator, they are going to be contacting the worker and making sure that we're going over the complaint, the information they provided, find out if we have any questions for them that can provide additional information, identify what is the scope of the investigation, what are the issues that are being presented. Is this something that appears to be localized to a store, or is it something that would spread across a number of stores or all of the stores? Is there a just cause component to it that we are going to also expedite, especially the worker wants to return to the workplace? Once we do that, yes, we do reach out to the company and ask for records so that we can obviously verify the information. We have a team of not just attorneys, but data scientists who are going to be looking at the data and make sure that we can do the calculations based on the allegations and what the documents from both the workers and the company are showing that there are any violations. We will reach out then to the company with our findings and engage in a process to hopefully resolve the case.
Is there anything required either by the statute or via rulemaking that specifies a specific time upon which the agency must let a company know that a complaint has been filed?
No, there's no specific
So the
timeframe.
reason for this line of questioning is I am concerned it's taking the agency a very long time to close out these complaints, and certainly to the extent that companies are not being notified, that can lengthen the time at which it will take to resolve a complaint. So if a company is not being notified for 4 months, it's only going to drag out the time that we can get the worker the relief. So that's the reason why I'm very focused on this. And I would really urge that the agency establish procedures to let companies know once, in a very expeditious fashion, as soon as a complaint has been filed. We need to shorten the time frame it's taking the agency to close out these complaints so the workers get the relief.
I appreciate the concern, and really just thank you for caring so much about the work. As you said, obviously, our priority is to make sure that these laws are being followed, there's compliance, and that the workers get the restitution and that their rights are upheld. We have followed a process that has really yielded tremendous success for not just a large number of workers, but like we've said, in the tens of millions of dollars in worker restitution. Some cases are resolved very quickly, some might take a little bit longer. We want to make sure that we're doing a comprehensive review so that sometimes a worker may come with an issue, and in looking at the whole complaint and the cases, the documents that the company will provide to us, we want to make sure that we're addressing any non-compliance, any violations all at once. We don't want to have to go back. And we've been successful in our work, in the way we're doing the investigations, staying in touch with the parties to make sure we can move things along as fast as possible, but it varies per case.
I also want to mention we've been joined by my colleague, Councilmember Brewer. So in 2022, the number of days it took to resolve a Fair Workweek complaint was the highest it has ever been, at 345 days. That is more than 5 times the time it took in 2018, where it was 64 days. Why is it taking the agency so long to resolve these complaints?
Thank you, Chair. Our numbers actually show that for calendar year 2023, it did take 156 days to resolve investigations. Having said that, it really just varies in the type of case that we get. And
Yeah,
we
just to be clear, we're using 2022 data because that is the data that has been made public to us.
Well, I would note that this data is available, that in 2023 is available on our website as well. We do report it out every year, or I think around this time of year, earlier.
We're going from the MMR, so.
Okay,
But
so not calendar year?
if we could focus on 2022, because again, the data from 2022 is showing 345 days. It's 5 times more than it took in 2018. I'm trying to understand why that is so.
Well, I think what the commissioner was mentioning, and I think why maybe 2023 is, and the spread of the years is a good comparison, that we have trended downwards in the past year, albeit realistically that these complaints they vary in complexity and length. And so in one year you could have a longer, based on the number of cases we're taking in, you could have a longer length, and then depending on the cases you have for another year, they shorten down. For us, regardless, we are prioritizing this casework, as the commissioner mentioned, with our process to make sure we're expeditiously working through them.
So let's talk about the process of a typical investigation. How many staff are being assigned? And I understand each case is different, but if you could walk us through a typical investigation and how the agency is assigning staff and resources.
Thank you, Chairman. And we have, the OLPS has 44 staff members, and the amount of individuals, the resources that are put, they do vary. There's not a specific number that we set per staff. It's going to depend on the complexity of the cases and the size of the cases, but they all work in cases one way or another between attorneys, data scientists, investigators. There's a variety of them that are going to be assigned at cases, and we may reassign and move strategically, them around so that we can be sure we address the cases and we can move them along as fast as possible. It's not a set number per case or per investigator.
I want to mention we've been joined by my colleague, Councilmember Abreu. So in terms of the number of days it takes to resolve a fast food complaint, again, I'm using the 2022 data because that is the data that we have. It's 440 days to resolve the complaint in 2022, and that is significantly higher than the time for the retail complaint, which is 302. And I do just want to mention, 440 days, 302, to me, these numbers are too high. By way of comparison, in 2014, when we launched the city's paid sick leave law, which was obviously an incredibly comprehensive law, it took us in the first year 33 days to close out the complaint. So I am very concerned that these numbers are getting unacceptably high. So I want to understand even this difference between the time it's taking for the fast food complaint versus a retail complaint.
I just want to ask about the source of the numbers. Are we talking about the PMMR, or are we talking about
we're going
our
on the
annual
Worker
report?
Protection Enforcement Report.
So our annual reports. Okay, so that would be our calendar year numbers from 2022. And there, what we have reported is, in terms of time to close complaints, we have 400 days in 2022 and 156 days in 2023. And so definitely trending downwards in 2023. Those numbers will be on our website shortly, but that is what we are reporting for 2023.
For 2023. And what do you attribute that improved metric to? What is the agency doing differently?
So in the, I would say in around 2020 to 2021, we began really developing our team of data scientists who had the ability to move our process for analyzing employer records from a largely analog system that required an investigator to go through paper records to being able to evaluate records using data analytics much more quickly and efficiently. and that has improved our times to be able to resolve cases, in particular our workplace-wide cases.
How are you accounting for the Starbucks complaints in this data? Because again, we know that that you have a minimum of 76, if not probably significantly higher now, number of complaints, none of which have been closed out. And those first complaints were filed on February 14th of last year. So how is that going to affect the agency's response time?
I think one of the things that we'll want to look at is that the number of complaints that are filed are not necessarily going to be one-to-one, right, to investigations. We have a number of complaints that will come about the same business, and those are going to be grouped together. Having said that, there's a number of complaints that will come that refer to just cause cases, and in the Starbucks situation, there were 4 at least last year that we did resolve because they were specific to just cause allegations, and we do try to expedite those, especially, like I said, if the worker wants their job back. So it's not going to be matching, and again, I'll just point back to our successes because it has been record numbers that we have been recovering for workers. More people are coming, we're improving our systems, and we are confident that it's going to be, all of the numbers, you know, are going to continue showing our successes and improving our systems on the back end.
And I think something I'd like to add to that as well, especially comparing, I think, past strategies for looking into complaints is the proactive nature of these investigations. So if we did receive a complaint, and part of that, I think, reviewing of the complaint with the worker, are we identifying that this is not just something impacting a single worker, is it perhaps identifying the entire workplace? And in that case, that does take additional time, but that does lead to greater successes in terms of the amount of workers we're going to be able to bring relief to. And so, for example, I think when comparing that additional time, it's because we are processing a case that is adding many, many more workers than just one worker and resolving their case within, 30 days or something like that.
How much restitution was recovered last year in terms of workers?
In 2023, we recovered $12 million in worker relief.
And for how many workers?
9,580.
And how big is the staff at the Office of Labor and Policy Standards now, currently?
44.
44? How many vacancies are there?
None.
If any? None. Okay. And how many investigators of that 44? How many of the staff are investigators?
We have 19 on our investigations team.
Okay, I have many more questions, but I want to now turn it over to my colleagues to see if they have questions. Councilmember Brewer.
Thank you. First of all, without any qualms, I want to thank the agency for being the Zaza Waza heroes, for closing that forever and ever. And I want to thank you because nobody else has been able to do it. So I'm a big fan of your agency.
Thank you. You're welcome.
One of the questions is, how does the agency engage in investigations work for worker protection cases? Just a little bit more specific than what the great questions of the chair, and how much money has been secured for workers through that process? A little bit more detail maybe than what was asked earlier.
Thank you, Council Member, and thank you. Yes, we're very delighted when we are successful in our enforcement of the various laws that we enforce. In terms of the process, we have, Deputy Commissioner Wagner shared earlier how we've improved a lot in our process to receive complaints online, and so that's really helped workers come directly to us, make it easier, whether it's a computer, on their phone, answer specific questions that are helpful for us to expedite the back and forth and to shorten the back and forth that we will have with the worker. But that's the first thing that happens, is that it will come to our intake team, will be assigned to an investigator. They will engage with the worker, answer any questions, ask for any documents that may be helpful, and then we're going to contact the company and get records from them so that we can ask them, these are the issues that we're seeing, please provide the documents depending on the violations that have been identified. Our team of data scientists and attorneys, investigators will review those documents to come up with findings. and then those findings are presented in a letter to the employer. Sometimes we just schedule a time to pick up the phone and go over any questions. There may be some back and forth about it. They may provide additional information, and we look to resolve the case ideally through a settlement process so that we don't have to file a case. But if there is no agreement, we would then go to oath and file a case to continue the process and do any limited discovery if we need to, additional documents, and have a trial date, and then a decision is issued.
Okay.
And I think I would add to that piece on your question about the results for workers. Under the administration, we've been able to secure, I believe it was 37 million in restitution, primarily restitution for workers. So it's for us, it's definitely a core piece of our work and something we're very proud of.
When you mention oath, has the money been able to be secured? Because sometimes I know oath, when I try to understand when you have this huge number of uncollected dollars, not necessarily from you, property taxes, et cetera. In your case, you feel like you've been able to secure the funding, because I know some agencies are not.
Yes, when it comes to worker restitution, we have been highly successful in actually giving that money to the workers and not just claiming that we resolved the case.
Okay. And then just quickly, because I feel strongly about paid sick days, with all due respect to the de Blasio, it was my bill, I passed it. Just point that out every time. Are those cases seemingly getting more prevalent? We're trying to have, as you know, more information about publicity so people know that paid sick days exist. So I just would love to get, I know the speaker referenced, the chair referenced it, but I just want to get a little bit more information.
Yeah, no, thank you again. And again, thank you for your making sure that this law was in the books. Is incredible protections. We do a lot of outreach to make sure that the individuals that are covered, every single worker in New York City, right, knows about their rights. So that is something that we focus on to get the word out. They do come in at a pretty steady pace, I like to say. In terms of, I know the last additions that were made to the law, for example, so right now we're engaging with the private bar, educating them and make sure that if there is that additional action, right, the additional opportunity for individuals to file the private right of action and exercise that private right of action, they can also do that, and that the private bar has the right information to do that. We haven't been notified as of yet of any of those. It just went into effect, right, not that long ago. But it is a constant topic for us in all of our outreach work, and sometimes very focused depending on the industry that we're talking to.
Okay, and I don't know this, but domestic workers, do they fall under this category that we're talking about today?
Not for Workweek, unless they also happen to engage in that work.
Okay, thank you very much, Madam Chair.
Thank you. I also want to note we've been joined by Majority Leader Farias, and Councilmember Abreu has some questions.
Thank you, Chairman, and thank you, Commissioner Mayuga. I have two to three questions. What resources does OLPS need to improve enforcement of the Fair Workweek law?
Well, we're fully staffed in OLPS to conduct the work that we do. We've have incredible success. Certainly, more resources always, you get to do more. We don't have, we haven't quantified, how much more of what would take us to a certain level, but we certainly would want to have those conversations. And should our mandate increase, then we would definitely want to have conversations so that we can keep the pace, or if there's anything new, we can be sure to have the conversations also with OMB and ensure that we are doing our job.
How many outreach and education events were conducted in 2023 and in 2024? And how much of that outreach is targeted towards specific employers or employees who may not understand their rights and obligations under the law?
Thank you for the question, Council Member. I think our outreach team does amazing work. I like to say that they're probably one of the hardest working outreach teams in the city. But overall, since the start of the administration, we've completed close to 1,500 events on average. I think about 620 to 650 events per year. About a third of those are geared towards worker rights and business compliance.
Fun fact, I used to be an outreach employee under Julie Menon when she was commissioner. So excited to be here today and hearing the work continuing. Thank you so much. It's all coming full circle, for sure.
And I just want to have on the record, he did an amazing job.
Thank you, Julie.
Okay, I'm going to continue with a few questions. So how do you track the investigations? What kind of tracking system is the agency using? And is that data public?
The results from the data are public. What we use is a system called METS. It's a database where we track all of our intakes and then separately all of our investigations opened.
And how many investigations have been opened in 2024 to date?
For all of our worker protection enforcement is 134.
I'm sorry, what, I couldn't.
134 the first quarter of 2024.
Okay. How often does the agency open independent investigations that do not have a precipitating complaint?
That do not have a what, I'm sorry?
Precipitating complaint.
Thank you. They're telling me because I get some of the terms are different in my head. So, in terms of proactive, I mean it's across all of the. We don't track it that way, so I don't have a number or like a percentage to share. I will say though that when a complaint comes in, our way of taking proactive action is doing some of the stuff that I was mentioning earlier in terms of checking not just for that individual, but for the entire workforce at a place based on what the individual is saying, right? Making sure that is it just one issue with the law, or is it multiple issues within the law, or is there another law? For example, if somebody's coming with for a work week, but we're gonna ask them about paid save and sick leave and make sure that that's addressed as well, and vice versa. So it all comes together to make sure that we are not missing anything.
Mm-hmm. In terms of the outreach events that Councilmember Brea was asking about, you mentioned there's 650 a year. How many are done in multiple languages, and can you talk about language access?
I do have the numbers, but I can't, for events done in other languages, I just don't have them with me, but I will get that to you. I think across the agency, let's say on the outreach team itself, we have, I think, 7 languages spoken. Across the agency, I think half of our staff speaks a language other than English, covering about 44 languages. So we're certainly able to leverage those folks strategically to bring them to situations where we need more language access. On top of that, we do have our vendors that we will bring out too to bring in-person interpretation. And certainly too, when we want to develop complaints in the field, we have access to language line too. But typically our partnerships with community-based organizations are very important in this circumstance as well. We are working with organizations in the community that speak those languages too, and they also help us facilitate education and complaints.
And can you just repeat the total number of events the agency has done since the law's inception?
Since the law's inception, we have done 1,400 events on workers' rights, and that in those events we're talking about Fair Work Week, paid safe and sick leave.
So just a clarification, if it's 1,400 events since the law's inception, I don't understand the figure of 650 events per year.
Well, that's that figure, 650 events per year, is referring to this administration. So from 2022, 2023, and we're on pace for that in 2024. The law taking effect in 2018, we were able to, that's where those numbers come from. I'm sorry.
Understood, understood. In terms of, again, getting back to the crux of why I was very interested in having this hearing, which is the amount of time it's taking to close the cases, what can the agency do to reduce that time frame? What proactive steps is the agency considering doing to shorten the overall time frame it is taking?
Well, I mean, we're always looking at any ways that we can shorten that and just get better and more efficient. I mean, we try to look at technology. Deputy Commissioner Wagner was mentioning how, especially in the last couple of years, looking at our data scientists and their expertise and their skill to be able to go quicker through data and not so much paper. That does take longer. Those are some of the ways in which we try to, address different situations. Even our system, even just receiving the complaints with the information on a computer, that you're not dealing with handwritten right? Information that sometimes is hard to understand. You have it all typed up. We've been able to ask very specific questions in our complaint form online to make sure that we get all of the information in one shot and minimize the back and forth. Those are some of the ways in which we are, continually looking.
Did the agency submit to OMB anything regarding new needs in terms of Fair Workweek enforcement?
We're constantly in conversations with OMB. I will have to, give you specifics later on any specific request that was made during this budget process. I'm assuming that's...
Sorry, I couldn't hear the answer. Sorry, the sound system is not great here.
That's okay. The conversations with OMB are constant, very constant with them, primarily focusing if we have any new mandates and make sure that we are getting those needs met and funded. But I don't have any numbers right now to share on any specific.
Okay. Again, I would urge, I am deeply concerned about the length of time it's taken to close these investigations, the open Starbucks complaints. It just strikes me that the agency is being asked to do a lot with somewhat limited resources. Very important to get new needs in there to make sure that the agency is properly resourced and staffed. I know the Majority Leader has some questions.
Thank you so much, Chair, and thank you folks for being here today and testifying. I'm a former server and bartender. Shout out to all the restaurants and the Applebee's I used to work for. But just some questions around compliance and like your relationship with getting employers' information or data. What's our communications like with, other than outside of these outreach events and these events, to employees and letting them know what their actual rights are and like the tools that we have as a city for them to make any complaints? What is our relationship with businesses, and how do we make sure, like, if there's an open line of communication around their compliance or not?
Thank you for that question. We engage definitely with the employers as well. I mean, our goal is always going to be compliance. We want them to know how to comply with the law, so we do a number of things. At least during my tenure, I know I've had roundtables with major companies and their leaders or executives to make sure that that line of communication is always open, and if there's any confusion or questions about the law, they can reach out immediately and we can answer them. We also have, we do webinars. We have a YouTube video, for example, also on our website that we've sent to employers, the industry, so that they know how to comply with certain aspects of the law. We have forms, Google Sheets, spreadsheets with formulas embedded in them that will help them comply with the law as well if they have questions about it and support them that way. We have a very extensive FAQ document available to them, and that we can, continually updating and communicating with them so that they can have all the information, has real life examples, especially as we do investigations and find issues that may be nuanced or maybe we see them a lot, and we want to make sure that they have specific answers to the specific situations that we see.
Okay.
I think two pieces I'd like to add to that. One is we've recently updated our Worker Bill of Rights booklet, which is probably one of our most popular outreach devices we've ever had. It's comprehensive in terms of all the worker rights, not just that we enforce, but that belong to workers at the state and federal level, in a booklet that folks can use. And then just historically, social media as well is a big tool, and paid advertising on high visibility street furniture is something we also have utilized in the past.
Okay, I guess for me, in terms of like compliance or tracking, as someone that was like in a former industry that I really relied heavily on management to know, especially, I wouldn't know what I wasn't, like what I didn't know, right? As a young team member that had odd hours, I was getting paid a lower minimum wage because I was a tipped worker or tipped wage worker. I'm wondering, is there any DCP tracking compliance software approved by the agency or that maybe we utilize? I'm hearing spreadsheets and like formulas that we've set up to maybe support businesses' efforts in maintaining documentation, but do we have anything that's approved by DCWP to help employers comply and keep track of that compliance?
We are actually working on a project with a number of scheduling software providers to ensure that the rules and processes they're coding into their systems that they sell to employers are supporting compliance. We don't endorse any particular software,
Sure.
but what we want to do is just make sure that they have the sort of very detailed analytics within their systems that are compliant. And so we're continuing to be in touch with them to give them what they need and hear their feedback about what they need from us.
Okay, so it sounds like we are trying to have at least New York City's rules, regulations, compliance measures be put into software that might be utilized by businesses.
That's right.
Okay, and are we trying to aggregate any of that data for analysis or for violations or to help maybe match complaints to any of the maybe software?
We wouldn't get the data from the software companies in that way. However, if we get a complaint that we're then investigating, part of what this would ensure is that all of the data points that we're looking for to show compliance or non-compliance in our analytics are in the software systems that employers are using, which will facilitate us being able to see whether things went wrong or not. That said, part of what we want to do with this is ensure that there are no victims in the first place, there are no violations in the first place, and using software to help achieve that.
Just in this dialogue alone, my gut is to say, like, forward thinking, we should kind of look towards having a municipally run system. Maybe that's free or lower cost that people can opt into. That could definitely be a future budget ask, as our chair has mentioned, of making sure we have these budget asks that go in from the agency. I think most of us know, even for something simple that's top of mind right now from what we recently did with filing taxes, the free option that's maybe has a few more notches that you have to fill out is more cost efficient and reaches more people than maybe some of the larger options that maybe don't necessarily always connect for folks. So I would encourage you folks to think about that in the future. Thank you for answering my questions, and thank you, Chair.
Thank you. In terms of the Workers' Bill of Rights, how are you disseminating that information to workers?
So I guess we're working on two different tracks in terms of disseminating the information. One, there is a requirement for employers to post the Worker Bill of Rights at the place of business as well. So we have, for example, I've been sending communications out to our licensees, to health permittees. We've also been, and that's on the business side, we've been sending it to our entire business association list, which is over 600 groups. And then on the worker side, we've been thinking about how we can ensure that it is accessible in many different places for workers. So something we recently did is be in touch with our colleagues at DSS and ensuring that the Worker Bill of Rights will be presented at all shelters and posted at all shelters. We're also sending it out to our list of 1,200 plus community organizations. I think on the ground outreach, we really plan to start around May 1st and do out the whole summer. Again, working closely with our community partners, I'm really looking forward to that in terms of getting back out in the field. Not just presentations, but we also do canvassings to make sure that we're engaging with folks at different points.
I know that the council, we'd be very interested in partnering on that, having council members partner, have it in their newsletters, we are helping to disseminate the information. Also want to suggest a day of action. We did that when we launched a paid sick leave law. It worked incredibly well at subway stops throughout the city and other places. We also did that around nail salons, where we did a nail salon day of action, where we literally went business to talk to workers, to let them know about the rights, because even though it's required to be in the place of business, oftentimes workers may feel fearful or about filing any kind of complaint. They're worried about retaliation. So I think it's so important that we meet workers where they are to let them know that we are there for them in terms of these complaints being filed.
Thank you so much. It's very exciting, and I hope, through social media, for example, I hope every city council member is following us, because we do put a lot of information that helps get the word out, push out more information, as well as we have a newsletter also with updates on like cases and recent accomplishments and things like that, that if any of our city council members are not yet subscribed to it, we would love to have you subscribe to it as well and help us get the word out.
And Councilor, I'll certainly ensure that every council office receives the Worker Bill of Rights too.
Great, thank you. Couple final questions. I want to get back to the utility safety workers. What outreach has been conducted for them?
I think the principal outreach we've done is to work with their representative organizations about these rights and to maintain those channels of dialogue with them. Again, I think after that law was passed a few years ago, those organizations were successful in putting together a new collective bargaining agreement that offered analogous protections or better protections. But again, we're always want to be vigilant on that, ensuring that employers are complying with the law.
Is there a difference between a franchise and a corporately owned fast food employer in terms of the length of time it is taking to resolve complaints?
No, there is not.
Okay. And how is the agency responding to complaints involving changes to an employee's schedule? And does the response differ if the employee is part-time or full-time?
It would not matter whether the employee was part-time or full-time. And with any Fair Work Week complaint, we're starting off by doing an interview of the complainant to understand the scope of the violations, issue spot anything the complainant may not be aware of, and identify whether there are other workers affected.
Okay. In terms of 2024 data, can you give us a sense of the number of days it's taking to resolve complaints so far in 2024?
115.
Okay, thank you. That concludes my questions. I just want to once again see if my colleagues have any additional questions. No? Okay, thank you very much for your testimony today.
Thank you.
Thank you, Chair. And we'll make sure we have folks looking at worker advocate testimony and business testimony as well.
Great, thank you very much. Okay. All right, terrific. So I'm now going to open the hearing for public testimony. I want to remind members of the public that this is a formal government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you'll have 2 minutes to speak on today's hearing topic, which is, of course, enforcement of the Fair Workweek law. If you have a written statement or additional written testimony you wish to submit for the record, please provide a copy of that testimony to the Sergeant at Arms. You may also email written testimony to testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted, and I am now going to call the first panel. Autumn Weintraub, Max Pilcher, Lee Lambert, and Autumn Segara. If you can all please come up, thank you. In 2 minutes, right? Okay. Musical chairs. Okay, thank you so much. So you may begin, yes. Oh, just press the button until you see the red light.
Okay. Hello, Committee Chair Julie Menon and members of the Committee on Consumer and Worker Protections. My name is Autumn Weintraub, and I'm the Fast Food Director at 32BJ SEIU. SEIU 32BJ is the largest property services union in the nation, with 175,000 members across 11 states and Washington, D.C., including more than 85,000 members in New York State. In the past several years, 32BJ has also been organizing fast food workers to fight for fair pay, better working conditions, and respect on the job, including partnering with Starbucks Workers United. Through our work, we have become acutely aware of fast food workers' struggle to get sufficient and predictable hours and pay, and the challenge of attempting to resolve violations of workplace laws on a case-by-case basis. The Department of Consumer and Worker Protection's critical efforts to implement and enforce the Fair Workweek law have gone a long way towards improving scheduling standards in the low-wage fast food industry and have aided countless low-wage workers, but violations do persist. We believe a citywide investigation into Starbucks, a repeat Fair Workweek violator, can help ensure ongoing and sustained compliance within the company and in the broader fast food sector. The fast food sector is rife with workplace violations and characterized by poor labor standards. In 2023, fast food workers saw the lowest median weekly earnings of over 350 industries surveyed by the Bureau of Labor Statistics, a mere $610 a week. Fast food corporations, meanwhile, continue to pull in ever-soaring profits. In 2021, the top 7 publicly traded fast food companies earned $16 billion in profits and paid out over $12 billion to their shareholders in the form of stock buybacks and dividends. And the industry has grown rapidly over the past 2 decades, especially in New York City. While employment in the sector fell during the pandemic, it has again been climbing as the city's economy and employment recover.
Okay, I just have to ask, because we are required to make sure that every single person has the exact same amount of time. So if you wouldn't mind wrapping up and if you want to submit your written testimony.
Sure. We just wanted to say that DCWP has demonstrated itself to be a strong advocate for workers' rights. It's effectively enforced the Fair Workweek law, and there's been notable successes and settlements like the Chipotle one for $20 million. And over the past year, 83 Starbucks workers have filed Fair Workweek complaints across 63 cafes in New York City. These allegations are widespread across Starbucks, and the company continues to violate the Fair Workweek law. In light of the announcement that there is a foundational framework with Starbucks United and Starbucks, we still believe, even though it's a promising step forward, that there needs to be a system-wide investigation.
Great.
Thank you.
Thank you very much. Okay.
Do you want to go?
Hi, and good morning, Chairman and members of the committee. My name is Max Pilcher. I'm a Starbucks worker at the Starbucks store at West Broadway and Leonard Street. Prior to working at Starbucks in New York, I worked at a store in Iowa, but it wasn't until I came to the city that I started to experience the vast scheduling issues that I've experienced now. It was night and day, frankly. My hours have consistently fluctuated outside the 15% allowed by the Fair Workweek law, where I might have received 30 hours one week, 20 hours the next week, well outside that 15% standard. I also had issues where I was being scheduled outside the availability windows that I had provided to my manager. Eventually, things came to a head last summer, and I filed a Fair Workweek complaint last summer with the Department of Consumer and Worker Protection. So it might be hard for those that don't depend on scheduled hours for work to understand how much an impact the scheduling of hours has on people like me, but it impacts everything. It impacts how I plan my time off, my week-to-week finances, what bills I'm able to pay, whether I'm able to pay my rent in a given month. Everything depends on my hours. So this is why the Fair Workweek law and the work that they are doing, the DCWP is doing, is so important to workers like me. Currently, my complaint has not been resolved yet. I filed it last summer, but I'm hopeful that I will get justice. I wanted to thank the committee for hearing my testimony today.
Thank you very much.
Hi, good morning, Chair Julie. My name is Autumn Segura, and I said my name, I'm sorry.
No, that's okay.
I worked at Chipotle around John Jay. And during my time there, which was about a year, I got sick one day and I told my supervisor about my symptoms, specifically my kitchen manager. And when I came in a couple of days later for my shift, the company told me that I couldn't stay, that I could stay home. And I explained again that my previous shift that I attended to, I had told my supervisor I wasn't feeling good. I had COVID symptoms, and I was sent home. During the COVID resolution with Chipotle, you're supposed to talk to your worker, your employer, and let them know that you're not feeling good during shift, and they're supposed to put it into a system so they know that you're sick, and they're supposed to give you about 3 days off, and then they're gonna make you take another COVID test, and they never put that into the system. I was fired April of 2022. They claimed that I never reported any symptoms to the managers, and for Chipotle, that's an automatic termination. Even though it wasn't true, I was terminated. I refused to accept being fired that way, so I filed a just cause complaint. While it took over a year for the DCWP to resolve my complaint, eventually they did within a year and a half. I received $8,500 into my settlement, and $500 went to my lawyers that helped me. Thank them. I appreciate it. To be clear here, I didn't want the money. I never wanted the money in the first place, but that's what they offered to me because I wanted my job back with Chipotle, and they just didn't want to give me my job back. I'm sorry. That's all my time.
Okay, thank you very much for your testimony.
Good morning, Chairman and members of the committee. My name is Lee. I've been a Starbucks worker for nearly 3 years now. I currently work at the location on Church Street in Murray. Previously, when I filed my Fair Workweek complaint, I worked at the store at 100 William Street. I filed a Fair Workweek complaint. I was one of the first complainants in February of last year, actually. I was part of that complaint because my hours were cut significantly by more than 50%. Which had an enormous impact on my financial situation. I had to completely reorganize my life so that I could meet my expenses. It also threatened my access to benefits via Starbucks. I learned about the Fair Workweek complaint, and I was able to file about the Fair Workweek law, and I was able to file a complaint. To my knowledge, that complaint has not yet been resolved. As a working New Yorker, I really appreciate what agencies like the DCWP can do and how they work to hold large corporations like Starbucks accountable. And I think it's absolutely essential that they have the resources that they need to continue that work. Yeah, that's all I've got. Thank you for hearing me today.
Thank you so much. So I have a number of questions. So for Max, Autumn, and Lee, how did you first find out about Fair Workweek?
In my case, it was meeting with union organizers and being told about my rights under the Fair Workweek law, asking if I wanted to file a complaint. I know there is like postings in my store, but I didn't, somewhere in the back, but I hadn't seen those up until that point.
Yes, similarly, it was via work I was doing with 32BJ and Starbucks Workers United that I learned about the Fair Workweek law for the first time.
I was working within 6 months at Chipotle when I bumped into a 32BJ worker meeting another coworker of mine out of the job, and I asked a few questions, and they informed me that I was under the Fair Workweek law.
In any of your workspaces, whether that's you had a lounge or they're in back of house, for those of us that have back of house, where there's supposed to be signage of your rights, schedules, etc., was the Fair Workweek, postings ever listed?
In my store specifically in John Jay, there were, and after I was done asking questions with the union represent, and I came into my next shift, I had asked them about it, and they were trying to tweak. They were trying to tweak and critique some of the writings that was on the wall, saying that, oh, it's not within 72 hours that.
It's different interpretations they were trying to give you.
Yeah. Is sorry to bring this up, but I worked also in a store called The Little Beat, and that was over on 42nd Street. They also have a Fair Workweek law, a poster in the back of house, but they're saying that they don't fall under Fair Workweek laws, so they don't have to oblige by it.
Okay. Thank you for explaining that.
Okay. For Max and Lee, who have open complaints against the agency, what has the contact been with the agency? When were you filed your complaint, and when did you first hear back from the agency? How long, in other words, how long did it take the agency to contact you after you filed the complaint?
So I think Autumn can help me answer this question a little bit, because I did file through 32BJ, so I was not actually ever personally contacted by the agency. I do know, though, that they've had contact with 32BJ and with Starbucks Workers United throughout the process of investigating our complaints.
Yeah, my experience is the same as Lee's. I've not had any personal contact, but again,
Okay,
they
so
might be able to.
Autumn, can I ask you, how long did it take the agency to contact you or any representative of 32BJ after the complaints were filed?
After the union, 32BJ helped me set a complaint. I think it took a year for them to reach back out.
A year?
Do you remember?
It was probably that long.
Yeah, it took a year, and then after that, it took about 6 months for me to not even speak to Chipotle. Yeah, it was a whole debate when it came down to the settlement, because the Chipotle, the people who were trying to settle the money lower than what it was, they only wanted me in the room. They didn't want nobody that was representing me in the room with me. They only wanted me and solemnly me to be in a room with Chipotle COOs and discuss a settlement without any worker or lawyer. They were saying it's either the lawyer by themselves or just me.
Can I answer the Starbucks?
Yeah.
I think we'll get back to you with specifics on the reach out, but I think it was a few weeks and then a few months.
I'm sorry, if you could just speak up, it's a little hard to hear.
We'll get back to you on the specifics of the outreach from the agency and the timeline of it.
Okay,
I mean,
that would be helpful.
Yeah.
Autumn, I just want to go back to something you just said. So you're saying that you were not allowed to bring an attorney with you into the settlement?
That is correct.
Thank you. Last question that I have, so I guess it's for 32BJ. So could you give sort of a summary of what the experience has been like with these open complaints? Is there a good level of communication? Is there not? What has your experience been?
I mean, the experience is that I think they're huge corporations, and the work of the agency is incredibly important, and they're very, very hardworking. I think in general, they do their best to make sure that the companies comply and that the investigations go forward. I think on this particular case, it has been quite a while since there's been resolution, and so we hope that there's some sort of decision, either a resolution on some of the complaints, or ideally that because the violations are so systemic, that there'll be a citywide investigation. So we're hoping to hear some news on that soon.
Understood. Okay. Thank you very much to this panel. Thank you for being here. I'm going to call the next panel Peter Figul, Gabriel Seminiero. I'm sorry, this handwriting is a little hard to read. Edward Nesselclu, apologize if I mispronounced that. Christopher Leon Johnson. Okay. Thank you. Oh, you know, can you keep it here in case I have a question? Okay, Peter. Oh, I'm just going to go in the order that I called it. So Peter.
Yes, hello. Good morning, Chairman and members of the Committee on Consumer and Worker Protections. My name is Peter Fugil. I'm a postdoctoral research fellow at the Rutgers School of Management and Labor Relations. I'm currently conducting a comparative study of Fair Workweek laws in 8 different jurisdictions, including New York City. And this research is supported by an award from the National Science Foundation, although the views I'll be sharing today are my own. I have submitted written testimony, which includes detailed citations to some relevant studies. I just want to highlight a few points. One is that the Office of Labor Policy and Standards is understaffed relative to peer agencies. While the number of staff is the largest of the ones that I've looked at, when you take into account population, it's they have 8 times the caseload, for example, of Seattle, and similar, much larger caseload than San Francisco. Furthermore, the success with settlements has been remarkable, but it's not clear that this is the best measure of success for Fair Workweek enforcement. Even in the banner year of 2022, only fewer than 5% of workers covered by Fair Workweek received any restitution through a settlement. So we have to ask, what about the other 95% of covered workers? Unfortunately, this is difficult to evaluate with publicly available data. OLPS could help shed light by releasing more data, including tallies of the types of allegations, such as you asked for earlier. They can also partner with other stakeholders, including researchers, to conduct evaluation studies and help share the best practices, for example, around data analytics with peer agencies to deliver on the promise of a Fair Workweek, not only in New York, but across the country.
Thank you very much.
Before I start, I just want to point out that Ed is not here, so he won't be giving his testimony.
Okay, thank you.
Hello and good morning, Julie Menon. My name is Gabriel Seminario. I was a Starbucks partner for 3 years, and unfortunately last summer I was terminated around September of 2023. The issues I had raised in my Fair Workweek complaint that I had filed intersected directly with my termination. My manager had repeatedly scheduled me outside of my availability, which I had filled out for him many times. And one of the reasons my company terminated me was related to the day I was scheduled outside of my availability. And I had filed a just cause complaint challenging my termination. And unfortunately, my complaint is still pending. One of the other issues that I had was I had called in sick, and I did not have enough sick time. He told me that I was going to be written up as a result of that, so I came in while sick, and I had put in a schedule change log. I was ill while working, and he had also tried to penalize me for that as well. After losing my job at Starbucks, my financial situation was precarious. I had many bills that I was struggling to pay, and I had also just turned 26, so I was under my own insurance through the government, and I had to pay out of pocket for that. And I had been terminated right before Starbucks was going to give me their insurance, so I was struggling financially with that. I did fortunately get a job. Unfortunately, it was also minimum wage, so I was not making anywhere near as much as I was making at Starbucks. But now I currently work at Whole Foods and making almost as much. So currently my financial situation has almost stabilized itself.
Thank you for your testimony.
Hey, good morning. My name is Christopher Leon Johnson on the record. Let me make this clear. I used to be a member of 33J as a shop steward under the security division. So I know the plight of you fast food workers. I used to fight with you guys with the help of my business person, Benita Mercado, and Mr. Izzy Melendez. Let me make this clear, right? You know, what's going on is these corporations, they're really greedy and they're really corrupt. And what they're doing is what they want to do is try to find ways to save as much money as possible. The thing about unions is it's hard to fire people. Once you're part of a union, it's hard to fire people. And the thing that the unions have to make clear is that they have to help the employers get rid of bad employees. Because if you don't get rid of bad employees, it gives the businesses the ammunition to be anti-union. This goes on with Amazon. This happens a lot of places with unions like Walmart and mainly Walmart. But let me make this clear that for my last 1 minute, the deliveristas, they're going to have a hub down at right outside City Hall very soon. Los Ordenistas, right? Ran by them, Worker Justice Project. What you guys need to do as the city council is find a way to put these guys in the same category as the fast food workers so they could get the same rights and privileges as the fast food workers under the New York City workers fast workers law with the best city 14 days. If you just make them regular, put them in the division of deliveristas, it's not going to do anything. You have to make more bills and more laws instead of just saying, okay, when you make these people employees here, put them into the fast food division. And I hope you guys in City Council, you, Mr. Chairman, and Majority Leader Farias, you need to talk to Izzy Melendez and have him put the deliveristas with the help of Liga Galapa and Gustavo and Antonio and Alejandro and Martin. Wait, I know. Into the fast food division of 32BJ, not a separate deliveristas, because 65,000 deliveristas, you add them to the fast food division, it will save a lot of headache and a lot of paperwork, and they'll have a lot of rights, especially with the minimum wage laws.
I'm just going to ask you to wrap up.
Okay, yeah, especially with the minimum wage laws that they implemented, $20 an hour. So I gotta go. I respect you guys. I gotta go. Thank you for the time.
Okay, thank you. I do have a few questions. Peter, very interested in this research on other cities. So can you talk a little bit more about, you mentioned that there would be better metrics of success than the amount of restitution that the agencies announced for workers. What would those better metrics be?
I mean, we've already discussed some of them here today. Obviously, compliance with the law. Workers receiving schedules in advance or receiving appropriate compensation when there are last-minute schedule changes. Those sorts of outcomes aren't available in Bureau of Labor Statistics or census data, so additional research is needed. The only jurisdiction I'm aware of that has done a systematic evaluation study is Seattle. And I included links to some of the public reports available through the city auditor's office. And what they found, a team of researchers with the SHIFT project found that the secure scheduling law in Seattle significantly improved predictability and reduced the occurrence of last-minute shift cancellations. And that resulted in better quality sleep, better mental health and well-being for workers, and lower incidence of material hardship like difficulty paying rent or food insecurity. And so we know that it can work, but there's just been no study of that kind in New York City, and so it's very hard to say systematically how workers are doing under this law.
Thank you. I also want to mention we've been joined by my colleague, Councilmember Osei. Gabriel, I did have a question for you. You mentioned your complaint has not been resolved by the agency. When did you file your complaint?
I had filed my complaint in early October of last year.
And what has been the communication that you've received from the agency?
32BJ has been in contact with me consistently, making sure I keep updated on my case, getting all the documentation, and recently they told me my case was being taken, so I had to restate everything I told you to my lawyers.
Okay, thank you. Any questions? Okay, thank you very much for this panel. I'm going to call the next panel. Okay, it is a one-person panel. Joe Weinograd. He's not here. Okay. Okay, thank you. Give 1 second. Okay, is there anyone here who did not sign up to testify who wishes to testify? Okay, not seeing anyone, and we have no one, I don't believe, on Zoom. Then I am going to close out this hearing and thank everyone so much for being here today. Thank you.